My guest today is Professor Burt Neuborne, who's Professor of Civil Liberties and founding legal director of the Brennan Center for Justice at NYU Law School. He was also the National Legal Director of the ACLU and Special Counsel to the NOW Legal Defense and Education Fund and a member of the New York City Human Rights Commission. Welcome, Burt.
Thank you, Gill. Good to be here.
Yeah, thanks for doing this. So as I mentioned, I come from technology and economics. I have very little understanding of the legal aspects of the country, and actually to make it even worse, I am an immigrant here. So I came to the country in the 80s, and I often never ever think about the Supreme Court till the last 10 years, which is sort of a biased view of what the Supreme Court has done. So I picked up a paper from a few of your colleagues from Eapen and University of Michigan, and it's entitled, "Has the Supreme Court Become Just Another Political Branch? Public Perceptions of Court Approval and Legitimacy in the Post-Dobbs World." And they say here, have perceptions for the US Supreme Court polarized, much like the rest of American politics, because of the court's unique role for many years. It remained one of the few institutions respected by both Democrats and Republicans alike. But the court's dramatic shift, they say, and this sounds like an opinion, to the right in recent years, highlighted by its Dobbs decision in 2022, potentially upends that logic. So our audience, as I mentioned, Burt, tend to be more sort of technology and economics oriented. So I want to sort of talk about the Supreme Court first, and sort of a little bit of a history of the Supreme Court. How was it before? For me, the judicial branch, if it's not in the news, they're probably doing a good job. If it is often in the news, and sometimes I feel like last five years or so, it feels like it's watching a baseball game that has the same score, 6-3. And if we have that type of a game, there is no need for a game. I mean, you just stay 6-3 and go in one direction. So what do you think? What do you think is happening?
Well, the Supreme Court is a fascinating institution. I mean, as you point out, Gill, in recent years, there's been a huge upsurge of criticism of the court, coming mostly from the left, arguing that the court has become a political institution. Now, as you point out, I've been involved in the care and feeding of the court for many, many years. I argued my first Supreme Court case in 1967. And served as National Legal Director of the ACLU during the Reagan presidency in the 1980s, and then founded the Brennan Center at NYU in the 90s. The one thing I can say with certainty is that people who lose before the court always claim that it's acting as a political institution. People who win before the court love the court and say that it's doing just what it should, and is deciding cases on the basis of law, not politics. And they're both right, because the court is an enormously complex institution. We start, if you read the United States Constitution, which I make my students do, it's amazing how many lawyers have never actually read the Constitution all the way through. They read the little piece that they're interested in, but they never read the whole thing and see how it fits together. If you read the whole Constitution, you'll be amazed that it doesn't say a word about giving the judiciary the power to declare something unconstitutional. That was not in the Constitution. It's never been in the Constitution. The court seized the power in 1803 in a very famous case called Marbury versus Madison, where the court said, look, if you give us a case and you tell us to decide the case, and one side says the statute is the law, and the other case says, no, the other side says the Constitution is the law, and you put the two of them together, what are we supposed to do? Of course we have to decide that the Constitution trumps the statute, if that's what we do. So they seized, they were the first judicial institution in the modern history to seize the power to strike down democratic statutes. And so they've always been controversial. When they did it in 1803, Thomas Jefferson had a fit. And claimed that the court was illegitimate and he was going to impeach them and he was going to throw them out. And throughout the court's history, whoever loses in the exercise of this enormous power is always prone to say that the court is exercising it wrong. So, for example, in the run-up to the Civil War, as again, this is American history and it's more maybe than you want to know, but the Civil War was 1861 to 1865, and it was all about trying to end slavery. So slavery was the dominant political issue in the United States from 1820 until the Civil War broke out. Every time the Supreme Court decided a case affecting slavery, it became a political lightning rod, and it tended to favor slave owners in the period before the Civil War, so that the judicial power maintained the power of slave owners. For example, they decided a case in 1841 saying that slave owners had a constitutional right to track their slaves down wherever they ran away and use self-help. They could use vigilantes. They could use paid slave catchers to catch slaves all over the North. And they would actually send people across the border into Philadelphia and seize people off the streets of Philadelphia and bring them back south into slavery again. And the Supreme Court said that's okay. It was a 7-2 decision, and there was a huge amount of controversy. During my life, during the 20th century begins with a Supreme Court that is preventing virtually every regulation of the free market. They are justices utterly committed to the idea of the free market and using something called substantive due process, which again, there's nothing in the Constitution that says that. They made it up. They used substantive due process to invalidate minimum wage laws, maximum hour laws, employee safety laws. They struck them down, and of course, it became a huge lightning rod. And so there was a huge effort in the 1910s and the 1920s to roll back the Supreme Court. Then Franklin Delano Roosevelt gets elected, and he has 4 terms, almost 20 years in office. So he completely repopulates the courts. By the time Roosevelt is done, you don't have conservative free marketeers on the bench. You have people who are committed to economic equality and regulation. And all of a sudden, they do a complete 180-degree turn, and they start upholding all the regulations, and they start encouraging Congress to pass more and more and more regulations. And so what we're seeing now is the end of that era and the beginning of a swing in the Supreme Court back to people who believe that the free market should be allowed to have more sway and who are who want to strike down regulations of the marketplace, especially when the regulations are carried out by administrative agencies that aren't elected and they're just in office. And so the administrative regulations are what the Supreme Court is really zeroing in on now.
Yeah, so, as somebody who studied economics, I'm sort of sympathetic to that view. But on the other hand, the little I know about law, law is not physics. In physics, we cannot interpret Newton's first law or Newton's second. There's no interpretation in physics. Well, there's some interpretation in quantum mechanics and string theory. There's stuff that we don't know yet. But
I don't know much about physics either. But little I read about physics, I thought there was no ambiguity in physics until I find out that particles can be in 2 places at the same time, and that really surprises me.
But the stuff that we know, the classical physics is sort of, everybody knows it. everybody anywhere would come to the same conclusion. But that's not the case in law. And so I've always felt that, when you have an opinion, a majority opinion or a dissenting opinion, they should start with, it is our opinion that, you know, and go from there, because it's not a fact. It is, there is no theory
Right.
supporting it in
You
any
make
way.
you make a great point. Actually, the European courts are even worse. European courts hide the fact that there's ambiguity and that judges have a choice. They hide the fact by one, never acknowledging that a choice exists, but also, for example, the Supreme Court of France, the Conseil Constitutionnel, is not allowed to issue dissents. Once the court decides, all of them have to march in the same direction, and they're not allowed to issue a public dissent.
Oh, wow,
So
okay.
it would be much better in the United States if judges acknowledged that they were not finding a single right answer, but finding the answer that seemed best to them,
Yeah,
and then disclosing what it is about that answer that made it seem best to them.
yeah,
So for example, I mean, one of the principles of American constitutional law is something called separation of powers. The
mm,
theory of the American Constitution is that we don't trust government. We want a government, but we have a love hate relationship with it. We would like a government that works, but we're also afraid that any government that's efficient enough to work is also efficient enough to be scary and to oppress people. So what the founders did is they decided that they would divide political power into three components: the power to make new law,
yeah,
the power to enforce existing law, and the power to answer questions about ambiguity, about what the law means in particular cases. And
yeah.
they gave each of those powers to three different branches. So the
Hmm.
Congress is supposed to make the law, the executive branch is supposed to enforce the law, and the judicial branch is supposed to answer the questions about ambiguity and the application of law in specific instances. And they are watertight compartments,
Hmm.
so that supposedly nobody can get hurt. The government can't hurt you unless all three branches agree, unless
Hmm.
Congress has made the rule, the executive has decided to enforce it, and the courts have let them do it. So you get so supposedly that's the theory. We're all safer because a single person can't get it into his head to
Hmm.
do something. He has to have this cooperation. Now, all of that might have made sense in the 19th century, but it's
Hmm.
absurd in the 20th and the 21st century when government became complex. Say during the Roosevelt era, when the administrative state was born, they invented this new creature called an administrative agency. And an
Hmm.
administrative agency is technically part of the executive branch, but it performs all the functions. It issues regulations, so it makes new law. It
Hmm.
decides issues. It decides when to enforce it, so it enforces the law, and that it actually decides cases in house. So the argument is that the current state of American separation of powers gives too much power to the administrative branch because
And
it's
that would be the DOJ for us. What
well,
is administrative?
the Securities and Exchange Commission, to
Yeah.
the Department of Justice, the FBI, the Consumer Finance Protection Board. I mean, all of the alphabet agencies that are up there. They all have this very significant power. And if there's one theme that's running through the current Supreme Court, and it is a 6-3 theme, um, six members of the court think that the administrative state has gone too far,
Hmm.
and they want to cut back on the power of administrative agencies to enforce the law effectively against large corporations or wealthy individuals. Three members of the court think that unless you give the administrative state that power, corporate America will walk over everybody. There
Hmm.
won't be enough government power to control them. And that's the split that we're seeing in the court on
Hmm.
case after important case. So, for example, I think it was today, it may have been yesterday, they decided this very important case about the Securities and Exchange Commission. The
Yeah.
Securities and Exchange Commission polices the American stock market. It polices the finances.
Yeah.
And believe it or not, it operates pursuant to two statutes that were enacted in 1933 and 1934. They have not been updated in all those
Hmm.
years since 33 and 34, but they're basically anti-fraud statutes. They say
Yeah.
that if you commit fraud and you don't give people adequate information about securities, you can be punished. You can be both criminally punished, you can be civilly punished. Um, um, Up until 2010, if the Securities and Exchange Commission wanted to come after you, what it would do is it would file a charge against you, and
Hmm.
then that charge would then be adjudicated in federal court before an
Hmm.
independent judge. In 2010, Congress changed the rules and let the SEC have their own in-house courts
Hmm.
so that
Okay.
one arm of the SEC prosecuted,
Yeah.
the other arm of the SEC adjudicated.
Hmm.
And so you had a mixture of functions where where the SEC was exercising both the power to make law, the power to enforce law, and the power to adjudicate disputes about the law. And that's
Yeah.
what the Supreme Court held unconstitutional, 6-3.
So, so let me ask you this, Bert. So, one of the justices in the Supreme Court recently said, one of the other justices, he is too much into history. He is missing the forest from the trees. And this is one of those situations, in some ways, I would argue,
Yeah,
which is we don't have 330 million equal people. We have 330 million highly segmented population. And, one of the decisions where corporations are people too. And so we don't have a system where everybody is treated equally. And so it's very difficult for me to see how I think we are really missing the forest from the trees. So what do you think about that?
well, I think it's true. I mean, you when you have a country with the kind of extraordinary diversity that we have here, making decisions about how best to set up law and how to enforce it is obviously a political decision. I mean, these are decisions that deal with politics. But if, for example, if you were to ask the people that wrote the SEC decision,
Mm.
if we were to sit them down here and say, now look what you just did. You just took a statute that was designed to deal with a crook who was misrepresenting information and manipulating information so that people who wanted to buy stock were being tricked into buying stock, thinking they were buying cows, and in fact they were buying pigs. And you lied to them. Why shouldn't we make it easy for us to convict?
Mm.
Why would we say, well, wait a minute, before we can, you shouldn't be able to have this convenient in-house court where the prosecutor goes across the hall and the judge then is part of the same team. And the argument would be, but wait a minute, you're assuming the guy's guilty. You just, if
Mm.
you assume the guy is guilty, why bother with a trial at all? You might as
Yeah.
well just go right to the punishment phase. But the fact of the matter is, one of the things that the Constitution requires is that before you impose punishment, you go
Mm.
through a painstaking process of adjudicating whether the person is guilty. And one of the important rights is the right to an independent jury,
Mm.
which is part of the judicial system, which the
Yeah.
SEC didn't have. So what it does is it guarantees this guy a right to a jury trial. Now, if he's guilty, he's going to get convicted anyway. But it's
Yeah.
more
So this is a good, sorry, Bert. So this is a good segue into there might be a very important case coming down on Monday, or decision, I should say, coming down on Monday. And um, I was told there are different possibilities. So I'm talking about the immunity Okay, so,
Yeah,
so
the
do you
Trump.
want to sort of set the context around this? Yeah.
Yeah, Trump's had a very good term in the Supreme Court. There are three cases that the court has two cases the court has decided so far, and one that they're going to decide on Monday. The first case that they decided is that Trump couldn't be kept off the ballot.
Yeah.
There's a provision that was passed in the years after the Civil War that said that if you engage in insurrection against the United States and you broke your oath of office to do it. It was aimed at the Confederates who
Yeah.
seceded from they were federal officials. They seceded from the country and they then engaged in an insurrection. They said if you do that, you can't hold office anymore. You can't. The argument was Trump did that by on January 6th
And that
by
was a Colorado
it was
court decision.
a Colorado court agreed that he engaged in insurrection. He had broken his oath of office because he had sworn as president to support and defend the Constitution. He had engaged in insurrection. Therefore, he violated Section 3 of the 14th Amendment. Therefore, he couldn't be on the ballot. And the Supreme Court reversed that 9-0. They reversed
Yeah.
it not because they had any quarrel necessarily with the merits. They didn't say anything about whether he engaged in insurrection or whether he violated Section 3. What they said was each state can't make its own decision about that. You can't have 50 different officials or in 50 different states and 50 different court systems deciding an issue like this. This is an issue that requires a single statute or a single mechanism to make a final decision, and that therefore only Congress can pass the statute that is necessary to do that. And Colorado didn't use that statute. So that was a unanimous decision. The court said, we can't have chaos here. There will be, if you leave us to 50 different states, there'll be a chaotic question about whether people can be on the ballot. And we have to have a much more carefully designed, a more efficient mechanism for doing that. That's the first thing. He knocks out the Colorado. The second thing was decided today. One of the charges against Trump that Jack Smith, the special counsel, has brought, is that he obstructed governmental administration. That by engaging in all these activities designed to prevent the certification of Biden as his successor, he was engaging in an obstruction of Congress. And what the Supreme Court held today is that charge is much narrower than Jack Smith thought it was. And it's a statutory construction case. This is a case involving a statute that said if you destroy evidence, destroy papers designed to stop some sort of administrative hearing, and you tear up the papers or you hide them or burn them, you've engaged in a felony. It was Enron. It was the Enron case. The Enron people destroyed all that evidence, and there was no way to get them because there was no statute. So right after the Enron case, they passed this statute that says if anybody engages in that type of activity, that's a felony. And then they throw in at the very end, or otherwise obstructs. Yeah. And so the question is, what does otherwise mean? Does otherwise mean any obstruction, or does it mean an obstruction that is linked to the destruction of paper evidence? And the Supreme Court held 6-3 today that you got to read that statute narrowly. And it doesn't mean any obstruction. It means only the narrow kind of obstruction that occurred in the Enron case. And again, it was 6-3. Reasonable people will differ about how you read it. Yeah. But since Trump is charged with one of those obstructions, it's very good news for him. And then the case that's coming down on Monday is the broader issue of whether a president has immunity, which is a magic word. I mean, I'm not sure. To this day, I don't know what it quite means. But immunity means that he's exempt from being prosecuted for things that he does in office. Presidents already have immunity from civil damages. So if you sue a president for something that he did in office, he says, sorry, you can't touch me, I'm immune, even after I leave office. So the question is, do you take that civil immunity and move it over into criminal immunity
Mm.
also, which means that he's above the law, which means that there's no way you can touch a president for anything that the president has done in office. And Trump, of course, argues that I could assassinate my opponents
Yes.
and there's nothing you can do about it because I'm the president and anything I do as president, I'm immune. Now the Supreme Court's going to reject that. They're going to reject his extreme position. But
Well, we don't know yet. But at this point, I don't know what the court does. Yeah.
well, I think you can bet the farm that they're going to say that presidents can't assassinate people. But the other extreme position is the position that the court took below, and that is that once you stop being president, you don't have immunity for anything.
Hmm.
I think the court's going to reject both of those extremes, and they're going to say there's a middle position, and the middle position is if you were acting as president, trying to carry out the laws, then you're immune because we don't want you to have to worry about whether you're going to get sued or indicted later. We just want you to be a vigorous and aggressive president. But if you were acting as a personal capacity and trying to advance your own personal ends and not to, then you don't have any immunity. And what they're going to do on Monday is they're going to send it back down to the district court for more hearings on that issue, which is just.
And if the ex-president wins again, he can appoint a favorable DOJ and then dismiss the case.
It means that Trump wins again because he slow-walked the whole thing to the point that nothing can happen before the election. After the election, who cares? And if he gets elected, he'll stop the prosecution. If he gets defeated, he'll disappear into the night. But he's been able to slow the thing down. And been very successful at it.
Yeah, so this is a forest from trees issue again. So when, as I was mentioning, Burt, I grew up in India and I came, to the US in the 80s, in the mid 80s. And I always felt US presidents are the best people. Character was extremely important. I remember a Democratic candidate, Gary Hart, was photographed on a boat with another woman, and that was the end of his campaign.
I know. Now it would make him famous. Now he'd be able to have a social media account.
But then now, we have a felon, apparently, with 34 felonies. But the American people, I have no political affiliation, by the way. I'm an independent. I never really worked for any political party. So just for the audience, but the American people don't seem to be too bothered about that. So culturally, we have moved along in the spectrum. Looks like, right?
I think so. I think we've changed. Just a word about the Supreme Court of India, which is a remarkable institution, which I've studied with great respect. They are the only institution in the world that claims the power to declare parts of the Constitution unconstitutional. When Indira Gandhi changed the Indian Constitution in a way that really threatened the existence of Indian democracy. The Supreme Court of India was remarkably brave and standing up and saying some of these constitutional amendments are so inconsistent with the ethos of the Constitution that they can't stand as amendments, and they struck down. Now, no other court has done that. The French Constitutional Court has come very close, but no other court has done it. And the United States Constitution, the Supreme Court in the United States would never do it. So I watched with admiration as they tried to defend democracy in India.
And they held again, Burt, as you know, just very recently. They held again. So this is one of the questions I want to ask you. So if a Supreme Court in a developing country, as you say, is superior to our superior court, Supreme Court, I should say, that always comes down 6-3. The score can be easily projected, easily
Not all the
predicted.
not all the time. They do come. It would be closer. It would be more accurate, Gill, to say that it's 3-3-3. I mean, there are nine
Yeah.
of them. Three of them are reliably on the center left. Three of them are reliably on the, I won't say far right, but fairly off on the conservative spectrum. And three of them are center right.
Mm.
And so it occasionally breaks down to more of a 3-3-3. Now, the center right people will tend to vote more with the far right people than they
Yeah.
will with the left people. But Roberts, for example, is really a centrist. He's like having the chairman of the Chamber of Commerce as your chief justice. I mean, he's really he made his great he was a great private lawyer, and he made his reputation as a private lawyer representing American industry before the courts, and that's why his triumph now are these cases cutting back on the administrative state. That's pure Roberts, and he's achieving that. But the court is such an interesting institution that way. I think you're right in saying that there's a forest and trees issue, and that raises what is the thing that at least formally divides the six right members, conservative members of the court, from the three liberal members of the court, and it's their methodology. The liberal methodology is, hey, this is all about the forest.
Yes.
This is all about how we can read the ambiguous words of this text to create the best constitutional law that we can for the world that we live in now. And it's the world that we live in now that matters, and not the world that existed in 1789 when the text was first adopted. The six members of the court say, where do you get that power from? Nobody elected you, and there's nowhere in the Constitution that gives you that power. That's too much power to say that you just want to read the words to give it the best meaning that you can for the time. We think we should have less power, and the less power is to say we're all about the trees. We don't believe in the forest. We only believe in the trees. And so what we're going to do is go back to 1789 and say, what did it mean then? And that's what we're going to enforce. And that's the historical move that they made. I find it intellectually dishonest. If history were physics, and you could go back to 1789 and actually figure something out, but history is about as ambiguous and subjective an idea. You know, it's there's a reason why, if you think about the word, it's his story. I mean, history is the story that everybody tells, and everybody's got their own story. So if you go back, of course you're going to pick a story that you think is right, and so they claim to be apolitical, but they're really using history to advance their political goals. I find that the liberal position is more attractive. At least they're open about the fact that they are engaged in some sort of political process. They don't pretend that history is making them do it. They take responsibility.
Yeah, so let me ask you this, Burt. So I've grown to be a bit cynical about the world. And I had a professor from Williams a couple of years ago, and he was telling me there was a Supreme Court decision in the 1930s, I believe, if I get the timing right, of a Japanese man applying for U.S. citizenship. And the case went all the way to the Supreme Court, and the Supreme Court said, you are not Caucasian, you cannot become American. And a few months later, the Indian man applied, and the Supreme Court said, yeah, the scientists tell us you're Caucasian, but look how dark you are. You cannot be American. And that was less than 100 years ago. And so if the Supreme Court, as they call it, originalism, want to rewind time all the way to 1800, I would say I mean, we had to wait till 1870, I believe, 1869, for before African Americans got um, citizenship. So if there is a Supreme Court justice who's neither Caucasian nor light-skinned, and he rewinds time to 1800, he's at risk of not being an American, right?
Well, certainly of not being able to claim that he's a citizen. I mean, they decided maybe the worst case decided in the history of the Supreme Court is called Dred Scott versus, um, um, and it's a case of a slave who had been taken into free territory by his master, and he argued that since I was taken into free territory, it's the law of the free territory that governs me, not the Louisiana law that. Since that was British law, that's the way that Britain got rid of slavery by that kind of uh, um, technical legerdemain. Dred Scott argued that, and they said, no, 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 you can't make that argument because federal courts only have jurisdiction for citizens of different states, and black people can't be citizens. That was not overturned until in the wake of the Civil War. Before the the major purpose of the 14th Amendment was to overturn Dred Scott. And it wasn't ratified until 1868. So it wasn't until 1868 that people of color could be thought of as citizens at all. Much less as equal citizens, but as citizens at all. And so that's why I find originalism such a troubling idea. I understand when somebody says to me, Burt, why do you trust judges this way? Why would you want to give them this kind of power to make decisions, make the kinds of constitutional decisions that we're talking about? They're just ordinary people. They get up every day. They put their clothes on just like you do. And the words that they're using are ambiguous words. It's not like the words make them do it. So they are engaged in discretionary behavior. Why do you trust them? And my sense is, well, I trust them because somebody has to do it. And so so there has to be a decision about what the law is. If there's nobody that can make that decision, then you have one of two things. You have chaos, a lawless society, or you have a society with the guy with the biggest stick gets to say what the law is. The guy with the most rocks gets to win, and that's impossible. So someone has to have this power. The question is, how do we exercise the power? And I hate the idea of exercising the power by saying, well, because we want to constrain the judges, we don't want to give them this kind of discretion. We'll lock them up in a straitjacket, and it'll be an 18th century straitjacket. It'll be
sorry, but what if we elect Supreme Court justices? Will that work?
Well, it could. I mean, judges are elected in 2/3 of the states. Most of the states.
But why not the Supreme Court?
Well, the argument is that if you elect the Supreme Court, then after all, the whole purpose of the Constitution is to protect the weak against the strong. I mean, if you've got the power to elect the majority, you don't need the Constitution. I mean, you've got enough political power to protect yourself. It's the losers that have to be protected. And if the Supreme Court is made up of the same political majority that you're asking the court to police, then the feeling is that the institution would be less effective. That it's better that it be insulated from politics if you're asking it to control politics. Now, there's such a thing as being too insulated. There's no reason why it has to be life tenure. There's a very interesting proposal on the table now to make the Supreme Court justices serve for 18 years. They would serve for 18 years, and then they would rotate off the court. And the good thing about that is once it went into effect, it would mean that each president gets to appoint the same number of justices. The way it works now, it's like a random crapshoot. Some presidents get to appoint 4 or 5 justices. Some presidents don't get to appoint any because it all depends on when people die.
Right.
And so it is it's a strange system. So this is an effort to make it more rational, but also to assure that there's political input into who the members of the Supreme Court are. Because if
Yeah.
the president gets elected, then he's going to appoint or she's going to appoint certain people to the court. And as long as each president gets a fair number of appointments, the court itself will tend to reflect the political constituency of the whole nation. And that it strikes me as being a very good reform.
Yeah.
And it can be done. And you don't need a constitutional amendment for it. That could be done by statute. If Congress were to do that, they could impose 18-year-old terms. When the person rotated off the court, he would still be a judge, but it just wouldn't be sitting on the Supreme Court. It would be a judge sitting somewhere else in one of the other courts.
So I want to go a little bit on a tangent, Burt. I just want to get your perspective on this. So the founders, I assume, were worried about the tyranny of the majority. And now we have sort of a tyranny of the minority in the sense that we have 50 states. The Senate can get a majority with 18% in the extreme of the votes, right?
Outrageous.
That we don't have it in any other democracy. No parliamentary democracy.
Madison apologized. He apologized for the Senate when people asked whether they should vote for the new Constitution, even though the Senate was such an undemocratic body. Madison said, "I can't defend it. I think on balance, we're better off adopting the Constitution than not. But I think the Senate is just an indefensible body, and it continues to be an indefensible body. I think 18% is a theoretical.
It's more like 39%, but
in practice it operates at about 40%. It means, but what it does do is the divide that it makes is not necessarily individual. It's urban rural. What the Senate does is it over represents the interests of the rural states and underrepresents the interests of the urban population. So it is we could fix it. You could fix the Senate tomorrow. If you give me a free hand, I will fix the Senate in 5 days. And the way to fix the Senate is that you can make as many states as you want.
So split California and New York or something like that.
Yeah, California gets split into 3 states. New York gets split into 2 states. You could even have a statute with a formula that as soon as a state has so many people that it's just that it requires some sort of fix to make it democratic. They automatically splits, and we've already done it. We did it with West Virginia was created out of Virginia, Vermont was created out of New Hampshire, and we've already done it a number of times. Done it 5 times, and if we made the District of Columbia a state. And if Puerto Rico wanted it, if we made Puerto Rico a state. And so if Puerto Rico were a state, the District of Columbia are a state, and we broke up some of the big states into smaller states, all of a sudden urban America would have a fair representation in the Senate. And it doesn't require a constitutional amendment. It simply requires consent by Congress and consent by the states. So you have to work out the boundaries.
Just a majority in the Congress? Just a majority?
Yeah, just a majority. Now, when I say just a majority, we'd have to get rid of the filibuster rule, because the filibuster rule means you can't do anything without 60 votes. But that ironically can be gotten rid of by a majority. A majority can end the filibuster tomorrould if they wanted to.
The majority of the Congress could end the Senate.
Majority of the Senate. Could vote to amend its rules and end the filibuster tomorrow. But both sides are afraid to do it.
But that's a backstop, right? I mean, I don't think either party is in a position to ever get over 60 votes in the Senate. We are stuck. We are stuck in some sort of equilibrium.
I think if the Republicans control the Senate in the next um, election cycle, they'll probably end the filibuster. They will not allow the Democrats to slow down anything they want. So
Mm.
it's it's the Democrats that cling to this idea that they should be um, careful and fair and not use all their power. They could have ended the filibuster during the Biden administration and enacted all the things that Biden wanted that have been held up by filibuster. And they chose not to do it. And it's a choice. I mean, they could have done it in a minute, and they just chose not to do it.
So they want the option, but they go out there and talk about it as if, we are the victims. But they want the option. That's the reason they want to keep it.
Well, they keep thinking that, gee, when we get out of power, it's better for us to have the filibuster.
Yeah.
What they don't seem to realize is that one side has no scruples about slashing and burning any of the limitations, and the other side stands there with the Marquess of Queensberry rules and wonders why they always get a bloody nose.
Right.
So you watch it and you see it happen over and over again. So back to the Supreme Court. How about
Yeah.
The free speech cases this term are interesting. I mean, the one thing we can argue about whether the court has been an effective institution. I mean, the two areas that you would argue most about over the years is what they've done in race and what they've done in free speech. More recently, it's what they've done in abortion that's gotten all of the publicity. But over the years, the most sustained impact that the Supreme Court has had is to
Mm.
build a legal structure highly protective of speech. And it's taken a long time. I mean, they started back in the First World War with some terrible cases in jailing the people who opposed American participation in the First World War. And it took 50 to 60 years to finally work out legal doctrine that really protects speakers. And now the Supreme Court is being called upon to apply that doctrine to social media platforms. And trying to figure out what the free speech rules should be for social media platforms are really fascinating. And so those are the cases that they're going to come down Monday also. There are two cases
Okay.
that are going to come down Monday about whether the state can regulate the assumption has been that social media platforms are like newspapers. They're like private speakers. They get to decide what they say, and they get to decide what gets said on their platforms. Now, Florida and I think Florida and Texas both have passed statutes regulating the ability of social media platforms to decide who can come on and who cannot come on. And so the question is, are they newspapers? Who get to publish whatever they want, or are they some other creature that's going to be regulated by the state? My bet is that the Supreme Court's going to say they're newspapers.
Yeah, so I was thinking about, the campus protests that have been going on, is sort of in a similar area, right? So will that affect a protest by a peaceful protest, let's say, in a university campus?
I don't think so. I think those kinds of traditional free speech rules are protected. Although you want to remember, Gill, that the vast majority of American campuses are private, and so they're not governed. They're not governed by the First Amendment.
So they can do whatever they want.
Yeah, people sometimes think that the First Amendment gives them protection. It doesn't give you any protection in the workplace. Your boss can discriminate on the basis of politics. It only protects you against the government. So that there's this interesting split. A school like Berkeley, University of California in Berkeley, that's a state school, so they have to run by the First Amendment. But a school like NYU, where the other place I teach, is a private institution and gets to make its own rules. And so it would be an interesting discussion. What a school should do. Because when you think about it, American higher education is at least four things. At least four things. One, it's a place where young adults are away from home for the first time from their parents. They live there. It's their home. Secondly, it's a factory floor where they work, if I have anything to do about it, relentlessly, to try to get knowledge and acquire skills. And then
Yeah.
it's a social greenhouse where they're supposed to mature and grow into the leaders of tomorrow. And then it's a marketplace of ideas where all ideas are supposed to compete, and we're supposed to move closer to truth because of it. So four different things. They're entitled to be secure in their home. They're
Mm.
entitled to have a fair chance to succeed on the factory floor. We want them to grow and evolve as ethical human beings in the greenhouse, and we want the university to be able to have a free fire zone of in. You can't get all four at the same time.
Yeah.
And being a university president and trying to advance all four of those values at the
Yeah.
same time is excruciatingly hard,
Yeah. Yeah.
especially today, especially with the
It's
passions.
nearly impossible. So I want to head back to the Supreme Court for just a minute. So I was looking at chart here, but how much trust and confidence do you have at this time in three branches of the government? And all three of them seem to fall from somewhere around 2001. And right now, the Supreme Court appears to be sitting at around 30%,
Yeah,
well below the legislative and the executive branch. That is, for a democracy, that's a pretty problematic situation,
well,
isn't it?
sure. I mean, well, the chart,
Yeah.
the chart that you're looking at is if it were a medical chart, you would
Yeah.
wheel the you would wheel the patient into an emergency room
Yes. Yes.
and start
Yeah.
administering. The faith in democratic institutions is at the lowest point in my whole life. I mean, I start, as I say, I argued my first Supreme Court in the case in the late '60s, and I've been politically active since the beginning of the '60s. I've never experienced an
Mm.
era in which my students are as cynical and as mistrustful of
Yeah.
it doesn't matter what the institution is. I mean, you name the institution and they think there's something wrong with it, whether
Yeah.
it's the police or the courts or the legislature or the presidency or the electoral college, um, or podcasts. I mean, you name it and they will tell you
For
everything.
podcasts probably appropriately. Everything else, I'm not sure. Yeah.
But it is. I stand up in front of my it's in front of my class. I start from the premise that maybe I'm just a incurable romantic. I believe in democracy. I believe in the idea of the rule of law. I believe that we can have civil government and tolerate each other. And I believe that our institutions should be reinforcing it. And it's tragic to me to
Mm.
watch the slow disintegration of the public confidence that we need to
Mm.
do that. If you identified one problem in American democracy now, it's the inability to be able to marshal spokespeople who can speak in a persuasive way and rally support for
Yeah.
the idea of democracy. Without meaning, I don't mean this to be partisan, but Trump is not a spokesman for democracy. He's a corrosive force. He makes you more and more cynical. Biden is not an effective spokesman, even though he wishes he could. His heart's in the right place, but he doesn't seem to be able to articulate it. When I was young, there were three voices that I heard all the time:
Mm.
Martin Luther King, John F. Kennedy, and
Yeah.
Robert Kennedy. Those three voices, plus Earl Warren writing for the Supreme Court. So you have the Supreme Court writing as a prophet, saying
Yeah.
we can be better than we are. We can improve. We can be better. And then you had people like Kennedy
Mm.
and King operating as moral forces, verbal forces. Now, the assassination of those three men has had an effect on this country that is
Forever. Yeah.
it's still the voices. There were no great
Yeah.
voices. So what the voice that supplanted that was the voice of greed and self-interest. that said it's okay to be greedy, it's okay to want to be rich, it's okay not to care about your neighbor. In the long run, the market will fix it all. And so these kids have grown up
Yeah.
without ever hearing a voice. I have all plenty of quarrels with Churchill, but Churchill, without
Yeah.
Churchill's voice, you wonder how Britain would have gotten through the war.
Yeah.
And we don't have those nurturing institutions that can bring those voices back is so critical because ultimately, as you point out, it's public support that
Yeah.
democracy and the rule of law rest on. It's not there's no magic to it. If the people
Yeah.
don't believe in it, it's not going to work. And it
Yes. So from my perspective, but um, we had a fairly simple heuristic to elect presidents and representatives in general, but presidents for sure, and that was character.
yeah.
And somewhere in 2016, we seem to have lost it.
Well, I think we lost
And
it beforehand
yeah,
in some sense. I think we began to lose it.
yeah,
And this is something I won't take personal responsibility to this, but I think one can try to look back and learn from mistakes. Um, one of the ideologies I was responsible for arguing it as legal director of the ACLU. One of the ideologies that took root in say the last third of the 20th century was this insistence on personal gratification, a
mm,
sense that your own personal need, your own sense to be who you are, your own sense to live out your own destiny, should be the dominant consideration, and that ideas of collective responsibility and
yeah,
belonging to a larger group and responsibility to the group became subordinated to that idea of individual stuff. I understand why it happened. It happened in large part because we were reacting against a totalitarian world, a Nazi and communist world that subordinated the individual to the group, and we were the world that subordinated the group to the individual.
yeah,
If you push that too far, you get uncaring individuals who only want to use their own power to advance their own ends, and they
mm,
forget that they're part of a larger world. And
yeah.
I think we've lost it, and we have to recapture that. And we can. I mean, but we have to recapture that kind of feeling.
Yeah, I'm a bit skeptical. From a scientific perspective, it's a very bad optimization problem in the sense that you have very fixed horizons. We haven't been able to extend life of humans, and it's very, very fixed, and so if you go through life with some monetary optimization problem, you're going to be so terribly disappointed when you leave, right? And we have countries out in Scandinavia and New Zealand, other places, Netherlands. People have come to this realization, which is, yeah, life is sort of short. So you have to optimize happiness rather than money. And I think we have lost that idea too, seems like,
I think
last 10, 15 years. Yeah.
no, I think that's right. I think that's in part that's what I meant by the voice of greed, that replaced the kind of argument about living a moral life. The argument was, well, you can, it's moral to be greedy. Adam Smith supplanted ideas of morality because the argument was you can be greedy, but somehow the invisible hand works to make everything okay in the end, and so it's all right for you to be. And the truth is, it doesn't make everything all right in the end. As you point out, the lives are not lives of fulfillment, and it can extinguish significant societies. And so, going back to the Supreme Court, if there's one institution that can help
Yeah.
us get back to that, it's the court, because the
Yeah.
court is right. In many ways, it infuriates me that it claims that it's always right and that this is the one right answer. I'm the judge and I know it. On the other hand, it writes with a kind of an authoritative voice capable of calling people to be better.
Yeah.
And
Sort of centering the country. I mean, if the Supreme Court were sort of center, then it could have a great influence on the country,
well,
right?
tremendous. It could regalvanize respect for the rule of law. It could regalvanize respect for democracy itself. What it could do is begin to um, 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 rebuild respect for institutions. That institutions are important. Now, institutions are just groups of people working together, but those institutions are important to make the system work. I disagree with him a great deal on many cases, but I have to say, I believe that the Chief Justice wants to try to do that. I mean, I think if you gave him the chance to build a centrist court, he would build that centrist court. And he's lost control of his court.
Yeah.
Because it's a 6-3 court. So if it's a 6, if it were a 5-4 court and he were the fifth vote,
right.
you would see a very interesting institution in place.
And you know, it's bad to be cynical about this, but if Republicans win again, we are heading to a 7-2 court,
well,
and that would be a disaster.
If Republicans win again, the court will become a free market court. We will go back to the law, much of the law, as it was before the Warren Court. The far right, what the far right's legal philosophy and the far right's legal program is to reverse as much of the Warren Court's decisions on equality as they can, and to dismantle as much as of Franklin Roosevelt's administrative state as they can. And if they could take us back to 1928, I don't think they want to take us to 1929. That was a bad year.
For obvious reasons, yeah. They might be at risk, yeah.
If they could take us back to 28, they'd be delighted. And that's not a world that, frankly, I think I would want to live in. I mean, that's a greedy, ugly world, and so there's a lot at stake in these.
There's a lot at stake in this elections. The problem we have, though, but I want to get to, I mean, you teach young kids. The problems are so complex from a policy perspective anymore that how do we teach, the 21-year-old?
Yeah, well, I'm blessed with not having to answer that question. Teaching to high school students, I don't know how I would teach this to high school students because it really is complicated. But I'm blessed at teaching at elite law schools, where I demand my students use their intellectual firepower, to use their analytics to actually break down the components and think about policy in ways that are other than emotive. Emotive thinking is fine. I mean, I think we have to have it. I don't think you could be happy in life if everything were purely rational. I mean, we need non-rational emotive thought. But the idea that public policy is driven by emotions is terrifying. I mean, any more than physics would be terrified by emotions. Ask Lysenko. Lysenko didn't do well when emotions were dealing with physics. So I just insist that we use our intellectual firepower. I mean, we're creatures with a pretty big brain, and if we can use it, we can develop better policy and better ways of making policy.
Yeah, but the 180 million to 200 million people who go to vote today, or in 4 months, the average education is less than high school.
Yeah, I know.
And so, so when I was growing up, you voted for policy. You didn't really vote for a person. Right? It has all changed now, even in UK and India, everywhere else. But how do people with less education internalize policy implications and make a decision?
Yeah, well, let me say first, I don't think an election is like a test. where there's a right answer and the smartest people will figure out the right answer. I think an election is a referendum on self-interest.
Yeah.
And poor people and people who aren't terribly well educated have a very interesting gut sense of what's good for them and what's not good
Mm.
for them. It's why juries work so well. You'd be astonished.
Yeah.
People on juries are not well educated, but I have tried dozens
And
of
they make the
cases.
right decisions typically,
They
looks
do.
like,
I
right?
can't tell you how many times I've tried to fool a jury, and the jury just won't let me do it. You throw the
Yeah.
fastball as fast as you can, and you can't get it past them.
Yeah.
They're very very wise, and I've learned to respect the jury, and that's
Mm.
helped me learn to respect the democratic process because the
Yeah.
jury is an extraordinarily democratic process. I mean, it is a
Yeah.
individuals exercise governmental power only 3 times in their lives. Who are not officials. They exercise governmental power when they vote. They
Yeah.
exercise governmental power when they serve in the military, and they
Yeah.
exercise governmental power in when they're on a jury.
Sure.
Those are the
Yeah.
3 times that they have direct power, and they do it well. They do it well when we give them
Yeah.
the chance. They do it well, and so
Yeah.
I think if we could give them the chance again, they listen. I don't have to pander to you. I was astonished to watch the Indian democratic system work. I mean,
Yeah.
this is a miracle. It's a goddamn miracle that you run an election over 5 or 6 weeks in extraordinarily physical conditions, and the vote is. It was heartwarming to see that.
700 million people. Yeah.
Yeah, it's amazing. It's the best advertisement for democracy we have.
I
And
hope it stays. I hope stays, Bert. I was a little bit worried, but things seem to be going the right direction.
yeah, it's always scary, but I have to say, if you had bet that India was going to continue to be a democracy 50 years ago, I wouldn't have given you that bet. And it's remarkable. And if India can do it, we can do it. We can do it here.
Yeah, I think it's likely. Yeah. Excellent. This has been great, Bert. Thanks so much
I've
for
enjoyed it, Gil. Thank you for
spending
the
time
chance.
with me.
Okay,
Thank you.
bye bye.